Dear learners, welcome to this session. Today we will be discussing the other sections of Immoral Traffic Prevention Act 1956 and human trafficking in India. You know, when we discussed this legislation, we found out that there are different provisions regarding, the definitions. Then there are different provisions which talk about what are the forms of sexual exploitation, and now we are discussing section 15 of the act, which talks about search without warrant. It says, notwithstanding anything contained in any other law for the time being in force, whenever the special police officer, if you remember, we have just spoken about the special police officer, now we have police officers in the capacity of anti-human trafficking units. So, in 1956, they talked about special police officer or the trafficking police officer, as the case may be, has reasonable grounds for believing that an offence punishable under this act has been or is being committed in respect of a person living in any premises, and that search of the premises with warrant cannot be made without undue delay. You know, if you just wait for the warrant, it will be a delay and people will escape. So, such officer may, after recording the grounds of his belief, enter and search such premises without a warrant. So, this is very important. The local informer has just told you that there is a crime going to happen or a crime is happening at a particular place, and then if you wait for the orders, then people may run away, the evidences may be tampered. So, you have to immediately raid the place, then you just write the reasons, record it, and you proceed with the raid. Any person who without reasonable cause refuses or neglects to attend the witness a search under this section, when called upon to do so by an order in writing delivered or tendered to him, shall be deemed to have committed an offence under section 187 of the Indian Penal Code. The special police officer or the trafficking police officer, as the case may be, entering any premises under subsection 1 shall be entitled to remove therefrom all the persons found therein. So, whoever has been rescued by the police officer, the special police officer will try to remove everybody from that place so that they are not trafficked or re-trafficked. The special police officer or the trafficking police officer, as the case may be, after removing the person under subsection 4, shall forthwith produce him before the appropriate magistrate. Any person who is produced before the magistrate under subsection 5 shall be examined by a registered medical practitioner for the purpose of determination of his age of such person, or for the detection of any injuries as a result of sexual abuse, or for the presence of any sexually transmitted disease. So, if you want to know the age, medical examination is very important. Then if you want to know whether some sexual abuse has been done with that person or not, then medical report is very important. And if that person is suffering from some sexual transmitted diseases, then also you need the report of the doctor. Before making a search under subsection 1, the special police officer or the trafficking police officer, as the case may be, shall call upon 2 or more respectable inhabitants, at least one of whom shall be a woman of the locality in which the place to be searched is situated, to attend and witness the search, and may issue an order in writing to them or any of them so as to do. So, this is very important. You have to call a woman. So, if you call a woman, then it is very important that if you are rescuing ladies, then you need to have a woman officer, provided that the requirement as to the respectable inhabitants being from the locality in which the place to be searched is situated shall not apply to a woman required to attend and witness the search. So, the special police officer or the trafficking police officer, as the case may be, and other persons taking part in or attending and witnessing a search shall not be liable to any civil or criminal proceeding against them in respect of anything lawfully done in connection with or for the purpose of the search. So, they have acted in a bona fide manner. They have acted to just protect the law so that the person is rescued and the entire process is not questioned later on in the court of law. So, you need people for conducting raids. So, if you are a witness to such process, then civil or criminal proceedings cannot be against you because you acted as a reasonable man, as a bona fide citizen and as a committed person. The special police officer or the trafficking police officer, as the case may be, making a search under this section shall be accompanied by at least 2 women police officers, and where any woman or girl removed under subsection 4 is required to be interrogated, it shall be done by the woman police officer. This is very important, that if you have to interrogate a woman or a girl, then you need a police officer. And if no police officer is available, the interrogation shall be done only in the presence of a lady member of a recognized welfare institution or organization to protect the dignity of the woman. Section 16 talks about rescue of person, where a magistrate has reason to believe. This is the role of the magistrate, how dynamic a magistrate can play in cases of trafficking, where a magistrate has reason to believe from information received from the police or from any other person authorized by the state government in this behalf or otherwise, that any person is living or is carrying on or is being made to carry on prostitution in a brothel, he may direct a police officer not below the rank of sub-inspector to enter such brothel and to remove therefrom such person and produce him before him. So, the police officer, after removing the person, shall forthwith produce him before the magistrate who has issued the order. Section 17 talks about intermediate custody of persons removed under section 15 and or rescued under section 16. When the special police officer removing a person under subsection 4 of section 15 or a police officer rescuing a person under subsection 1 of section 16 is for any reason unable to produce him before the appropriate magistrate as required by subsection 5 of section 15 or before the magistrate issuing the order under subsection 2 of section 16, he shall forthwith produce him before the nearest magistrate of any class who shall pass such orders as he deems proper for his safe custody until he is produced before the appropriate magistrate or, as the case may be, the magistrate issuing the order, provided that no person shall be detained in custody under this subsection for a period exceeding 10 days from the date of the order under this subsection, or restored to or placed in the custody of a person who may exercise a harmful influence over him. So, both these provisions are very important. When a person is produced before the appropriate magistrate under subsection 5 of section 15 or the magistrate under subsection 2 of section 16, he shall, after giving him an opportunity of being heard, cause an inquiry to be made as to the correctness of the information received under subsection 1. So, inquiry will be conducted to know whether the information is correct or not. about his age, about the character, about the antecedents of the person, and the suitability of his parents, guardian or husband for taking charge of him, and the nature of the influence which the condition is in his home are likely to have on him if he is sent home. And for this purpose, he may direct a probation officer appointed under the Probation of Offenders Act 1958 to inquire into the above circumstances and into the personality of the person and the prospects of his rehabilitation. So, the probation officer can do so many things. He can have a detailed report about, the nature of family environment he has, whether he will be able to rehabilitate in that family environment, whether the family is the safe place to keep that person, what are the circumstances in which, his dignity can be affected, his worth can be affected. This will also be considered by the officer. Then, his personality and the prospects of his rehabilitation, which is very important, will be looked by this officer. The magistrate may, while an inquiry is made into a case under subsection 2, pass such order as he deems proper for the safe custody of the person, provided that where a person rescued under section 16 is a child or minor, it shall be open to the magistrate to place such child or minor in any institution established or recognized under any Children Act. This is very important, you can place that child in a home which is recognized under the Children Act for the time being in force in any state for the safe custody of the children. We have Juvenile Justice Care and Protection Act. Under that we have homes. Provided further that no person shall be kept in custody for this purpose for the period exceeding 3 weeks from the date of such an order, and no person shall be kept in the custody of a person likely to have a harmful influence over him. So, best interest of the child is taken into consideration by the magistrate in deciding whether a child who is a minor or a child is safe at home. If the child is not safe at home, then the magistrate can order to keep him in a children home, and he cannot be kept under a person who can harm the child. Where a magistrate is satisfied after making an inquiry as required under subsection 2 that the information received is correct and that he is in need of care and protection, he may, subject to the provisions of subsection 5, make an order that such person be detained for such period, being not less than 1 year and not more than 3 years, as may be specified in the order, in a protective home or in such other custody as he shall, for reasons to be recorded in writing, consider suitable. So, he will just write the reason and justify his say that why he wants that the child should be placed. Provided that such custody shall not be held that of a person or body of a person of a religious persuasion different from that of a person, and that those entrusted with the custody of the person, including the person in charge of a protective home, may be required to enter into a bond. Very important, that the bond has to be signed between two people, which may, where necessary and feasible, contain undertaking based on directions relating to the proper care, guardianship, education, training and medical and psychiatric treatment of the person, as well as supervision by the person appointed by the court, which will be in force for a period not exceeding 3 years. In discharging his functions under subsection 2, a magistrate may summon a panel of 5 respectable people, so he can make a panel of 5 respectable people, 3 of whom shall, wherever practical, be women, to assist him, and may for this purpose keep a list of experienced social welfare workers, particularly women social welfare workers in the field of suppression of immoral traffic in persons. An appeal against an order made under subsection 4 shall lie to the court of a session, whose decision on such appeal shall be final. Section 17A, it is very important. Conditions to be observed before placing person rescued under section 16 to parents or guardian. Notwithstanding anything contained in subsection 2 of section 17, the magistrate making an inquiry under section 17 may, before passing an order for handing over any person rescued under section 16 to the parents, guardian or husband, satisfy himself about the capacity or genuineness of the parent, guardian or husband to keep such person by causing an investigation to be made by a recognized welfare institution or organization. So, the best interest is always the prime concern, and the magistrate always looks into the interest of the person who has to be placed. So, if the person is not safe with the parents, the guardian or the husband, then the magistrate will never place such a person under these people. So, an independent organization, a welfare institution or organization will investigate and submit its report, and on basis of the report, the magistrate can take a decision whether to send that person to his family or not. Section 18 talks about closure of brothel and eviction of offenders from the premises. It is very important, if you close this place at least for some time, that act will be stopped or restricted, because you don't have a place to operate. A magistrate may, on receipt of information from the police or otherwise, that any house, room, place or any portion thereof within a distance of 200 meters of any public place referred to in subsection 1 of section 7 is being run or used as a brothel by any person, or is being used by prostitutes for carrying on their trade, issue notice on the owner, lessor or landlord of such house. Public places you cannot have these brothels. So, he can issue a notice on the owner, lessor or landlord of such house, room, place or portion of the agent of the owner, lessor or landlord, or on the tenant, lessee, occupier of or any other person in charge of such house, room, place or portion, to show cause within 7 days of the receipt of the notice, while the same should not be attached with for improper use thereof. And if after hearing the person concerned, the magistrate is satisfied that the house, room, place or portion is being used as a brothel or for carrying on prostitution, then the magistrate may pass orders directing eviction of the occupier within 7 days of the passing of the order from the house, room, place or portion. So, it is again very important, directing that before letting it out during the period of 1 year, or in case where a child or minor has been found in such house, room, place or portion during a search under section 15, during the period of 3 years, immediately after the passing of the order, the owner, lessor or landlord or the agent of the owner, lessor or landlord shall obtain the previous approval of the magistrate. A very good provision. Provided that if the magistrate finds that the owner, lessor or landlord, as well as the agent of the owner, lessor or landlord, was innocent of the improper use of the house, room, place or portion, he may cause the same to be restored to the owner, lessor or landlord, or the agent of the owner, lessor or landlord, with a direction that the house, room, place or portion shall not be leased out or otherwise given possession of to or for the benefit of the person who was allowing the improper use therein. So, a very important provision, that if you prove that you were a bona fide person, you acted with due diligence and you were unaware of the fact that this place was being used as brothel, then the court will come to your rescue. A court convicting a person of any offence under section 3 or section 7 may pass order under subsection 1 without further notice to such person to show cause as required in subsection 3. Orders passed by the magistrate or court under subsection 1 or subsection 2 shall not be subject to appeal and shall not be stayed or set aside by the order of any court, civil or criminal, and the said order shall cease to have validity after the expiry of 1 year or 3 years as the case may be, provided that where a conviction under section 3 or section 7 is set aside on appeal on the ground that such house, room, place or any portion thereof is not being run or used as a brothel or is not being used by prostitutes for carrying on their trade, any order passed by the trial court under subsection 1 shall also be set aside. Notwithstanding anything contained in any other law for the time being in force, when a magistrate passes an order under subsection 1 or a court passes an order under subsection 2, any lease or agreement under which the house, room, place or portion is occupied at that time shall become void and inoperative. When an owner, lessor or landlord or the agent of such owner, lessor or landlord fails to comply with a direction given under clause B of subsection 1, he shall be punishable with fine which may extend to 500 rupees, or when he fails to comply with a direction under the proviso to that subsection, he shall be deemed to have committed an offence under clause B of subsection 2 of section 3 or clause C of subsection 2 of section 7 as the case may be, and punished accordingly. Application for being kept in a protective home or providing care and protection by the court is dealt under section 19. A person who is carrying on or is being made to carry on prostitution may make an application to the magistrate within the local limits of whose jurisdiction he is carrying on or is being made to carry on prostitution for an order that he may be kept in a protective home. A very good legislation, in terms of talking about rehabilitation and reintegration of the people in the society. So, an order can be asked for keeping them in protective home or provided care and protection by the court in a manner specified in subsection 3. The magistrate may, pending inquiry under subsection 3, direct that the person be kept in such custody as he may consider proper, having regard to the circumstances of the case. If the magistrate, after hearing the applicant and making such inquiry as he may consider necessary, including an inquiry by a probation officer appointed under the Probation of Offenders Act 1958 into the personality, condition of home, the prospects of rehabilitation of the applicant, is satisfied that an order should be made under this section, he shall, for the reason to be recorded, make an order that the applicant be kept in a protective home or in a corrective institution or under the supervision of a person appointed by the magistrate for such period as may be specified in the order. Section 20 deals with, removal of prostitutes from any place. Section 21 deals with the protective homes. Section 22A deals with power to establish special courts, and now we are seeing, fast track courts. Section 22AA deals with power of central government to establish special courts. So we have seen the Immoral Traffic Prevention Act 1956, and now we find a serious need to, just amend this legislation, keeping in view the aspirations and the changing dimensions of the present time. So technological intervention should be included in this act, and this act should be, amended to make it a comprehensive law on trafficking. Thank you for this session.